First of all, welcome to the 35th meeting in 2025 of the Delegated Powers and Law Reform Committee. I'd like to remind everyone to please switch off or put to silent the mobile phones and other electronic devices. The first item of business is to decide whether to take items 6, 7 and 8 in private. Is the committee content to take these items in private? Yes. Under agenda item number 2, we are considering an instrument subject to the affirmative procedure. No issues have been raised on the draft cross-border placement of children requirements, effect and enforcement Scotland Regulations 2026. Is the committee content that no reporting grounds are engaged? Yes. Under agenda item number 3, we are considering instruments subject to the negative procedure. Issues have been raised on SSI 2025-360. The Burial and Cremation Applications and Registers Miscellaneous Amendment Scotland Regulations 2025. The purpose of the instrument is to update the burial and cremation application forms, including by making reference to disposal of human remains by hydrolysis, and to improve the usability of the forms, and to amend the list of the information that cremation authorities must include in the registers. In the new form BF4, there is no authorisation section, which is included in all the other new forms. The committee asked about this, and the Scottish Government responded that this was not an intentional omission, that the regulations do not require this section to be completed, so it's currently completed as an administrative step only, with no operative legal effect, and that the Government will set out in guidance that this step should still be undertaken for the avoidance of any doubt. Nonetheless, the committee considers an authorisation section should have been included in the interests of consistency of the legislation. And does the committee wish to report this point on the general reporting ground? Yes. The committee also asked the Scottish Government a number of other questions about the forms in the instrument. The questions and answers were published online along with the papers for this committee meeting. And while the committee is not reporting these issues, the committee notes that the legislation is intended to improve the usability of the forms and that they will often be completed by bereaved individuals. And given this, does the committee wish to highlight its correspondence with the Scottish Government to the lead committee, in particular on questions 2 and 6? Yes. And finally, on this instrument, it also addresses an issue identified by the committee in SSI 2024-334, which the committee reported on the 3rd of December 2024. The Scottish Government committed to correct this issue at the next available opportunity. Does the committee wish to welcome that the present instrument fulfils this commitment? Yes. Also, under this agenda item, no issues have been raised on SSI 2025-380. Is the committee content that no reporting grounds are engaged? Under agenda item number 4, reconsidering instruments not subject to any parliamentary procedure. No issues have been raised on SSIs 2025, 377 and 379. Is the committee content that no reporting grounds are engaged? Thank you. And with that, we'll move to agenda item number 5. And we're taking evidence from Jenny Minto, MSP, the Minister for Public Health and Women's Health, on the non-surgical procedures and functions of Medical Reviewers Scotland Bill. The Minister is also accompanied by 3 Scottish Government officials. That's Owen Griffiths, the Legislation Team Leader, Rachel Coots, a lawyer, and Alison MacLeod, also a lawyer. I welcome you all to the meeting this morning. And before we start, can I remind you not to worry about turning on the microphones because they will be done for you. First, I'm going to open up to the Minister to make any opening remarks. Minister.
Thank you, Convener. I would like to thank the committee for giving me the opportunity to speak about the non-surgical procedures and functions of Medical Reviewers Scotland Bill today. Part 1 of the bill was developed in response to rising concerns about the potential for harm among members of the public seeking non-surgical procedures for cosmetic and well-being purposes. Its aim is to ensure that there is robust but proportionate regulation in place so that anyone who chooses to have these procedures can do so safely. The bill regulates non-surgical procedures. Those are procedures which pierce or penetrate the skin and which may require input from a healthcare professional, whether that is face-to-face consultation, prescription or medications or medical intervention in the event of complications. The bill contains substantive provisions which will make the public safer. It does so by making it an offence to provide these procedures to those under the age of 18 and by making it an offence to provide procedures out with permitted premises. Permitted premises will be safer settings by virtue of many of these settings being subject to oversight by Healthcare Improvement Scotland and being settings from which healthcare professionals provide or manage services. The involvement of healthcare professionals also supports safe and appropriate prescribing and will enable those healthcare professionals to intervene in the event of complications. These settings will be hygienic and adequately staffed. These provisions are key to protecting the public, especially young people, and will give clients confidence in the services they are receiving. However, the bill must not simply capture a snapshot in time. It is vital that it is able to respond quickly to changes in this constantly evolving sector. The bill, this was a key piece of feedback from those working in the sector. The bill, as introduced, takes account of the fact that new procedures, new technologies and changes to the way that procedures are performed will continue to occur in this sector and will need addressing in a timely manner to continue to assure safety. Whilst I understand that you have questions over the powers the bill takes, I'd like to provide reassurance today, as in my letter, that these have been carefully considered. The Scottish Government has set out its full policy intent in its recent public consultation and its documents and impact assessments, which have accompanied the publication of the bill. The regulation-making power in Section 5 will enable ministers to keep provisions up to date in future, as well as fulfilling those aspects of our intentions which we're not able to address on the face of the bill due to our consideration of the effects of the UK Internal Market Act. I would like to assure the committee that where regulation-making powers are taken, they will be supported by engagement with relevant stakeholders and consultation where necessary to ensure they remain proportionate and appropriate. And I welcome any further questions the committee may have.
Thank you for that, Minister. I think just for the public record, obviously the Minister and colleagues will be very much aware of my interest in this particular issue, as a constituent had raised it with me going back to 2018. So just for that clarification for everyone. Now, certainly for the questioning for today, we as a committee have already clearly undertaken much of our work, but we were seeking just some further information on a couple of points of the bill. So clearly Section 5 and that the aspect regarding leukemia is one of them. So we're keen to have an understanding as to where the matters currently stand in the Scottish Government's discussions with the UK Government regarding the application of the UK Internal Market Act 2020 to training and qualification requirements for non-surgical procedures.
And I think it's fair to say, just on your first point, that conversations I've been having across the Chamber about this bill shows a very clear nature of support to ensure from a public health perspective we get this right. So I very much appreciate the scrutiny that this committee as well as the Health Committee have been doing on the bill. So as you correctly pointed out, part of the situation with regards to UKEMA, if I can call it that, UK Internal Market Act, is that the fact that the Scottish Parliament, Scottish Government are unable to set training and supervision standards for Scotland within this area. And we feel that we consider that Part 3 of UKEMA would be engaged by this legislation that sets training standards for practitioners or prevents practitioners who do not hold certain qualifications or are not existing professionals from providing certain procedures. And that clearly was a concern for us when we were drafting the bill. As soon as we recognised this, we engaged with the UK Government, and I'm really pleased that that engagement has been very positive. It is ongoing, but we are engaging across this issue, because I think there's a recognition that we need to get this right. And as you know, the UK government are also looking at bringing in legislation around this area of public health concern. So it's really, we need to get it right for both people in Scotland, but also for the rest of the UK as well.
Okay. Thank you for that, Minister. So when you said ongoing, is it a monthly discussion or dialogue that's taking place, or is it more regular than that? Because obviously I think this particular aspect is really important for the legislation.
I absolutely agree, and if I can pass on to Owen, who has been leading the discussions from the Scottish Government's perspective.
So we've met several times. We met more than monthly over the summer to work with the UK government to understand respective understandings of the legislation, to help satisfy ourselves in our position that Part 3 of UKEMA was indeed engaged by this. And that engagement happens both with Department for Business and Trade, who lead on UKEMA, and also with colleagues in the Department for Health and Social Care, who are obviously leading on the legislation in this area for England, but will also face some of the same challenges as we have identified if they're to fulfil their policy intent as well. Conversations with DHSC are more than monthly. Colleagues with DBT were certainly more than monthly over the period of the summer, but we have not met with them in the last month, simply as we were sort of focusing on the introduction of the bill and we had information we needed from at that time. But those conversations will certainly be being picked up, both as this bill progresses and as kind of our plans and their understanding of this work also progresses.
Okay. So that sounds as if it's been fairly extensive engagement then.
Yeah.
Okay.
It had to be, and as Owen pointed out, it's not only just with the Department of Health from a health perspective, but also from a business perspective as well. Okay.
Yeah, no, that's helpful. Thank you. Ross McCall.
Thank you, Convener. Good morning, everyone. Hello, Minister, and everyone. Can I just also state for clarity reasons that we've met a few times regarding this issue, again, something very pertinent and not only in my area, but to me. Minister, thank you very much for the answer you've just given the Convener. And given that it's been quite extensive engagement, why have you introduced the bill before UKEMA position was resolved, given the extent to which the unresolved issues affect the core policy framework?
So UKEMA is one area of the bill, but I felt it was important that we brought in legislation, given the level of consultation that we have been carrying out over a number of years with regards to the safety around cosmetic procedures. And it's not just simply on the training, it's also ensuring that we have the right premises that are regulated properly so that clients are assured of the hygiene, the safety levels and the professionalism of the people working in it through the healthcare perspective. We also think it's very important that we're bringing in legislation to ensure that young people under the age of 18 cannot legally get this treatment, and that's a key driver of the bill. So we have focused very much on the age-related elements and also the premises, recognising that we ideally want to bring in the training and the professional qualifications, which we will do once we have achieved the discussions with the UK Government.
Okay, that's very helpful. Thank you. Thank you.
Yeah, thank you. Katie Clark.
Thank you, and I appreciate that there's already been a consultation and you'll be very keen, like all of us, to get legislation through before the elections and the Parliament rises. But would it not have been preferable to delay the bill or to introduce a further bill once the implications of the Internal Market Act were clear, so that the significant policy choices could be set out on the face of primary legislation?
So that has been considered. We have looked at that. We clearly do an options appraisal as we gain more information. But around Section 5, Section 5 isn't just purely focused on the Ukima situation. It also takes into account that this industry is very fast moving. The procedures can change around, so we may need the requirement to amend Schedule 1, but also from a safety perspective as well, the innovation of new techniques to provide the various procedures. So the bill needs to change to that, needs to respond to that fast-changing environment as well. And I think I go back to my response to Ros McCall, which is that there are other areas that can be brought in through this bill that are on the face of the bill, through the premises, but also through the age restrictions. And I think that's both of these are incredibly important from a public health perspective.
That's very helpful. Thank you.
Thank you.
Okay, thank you. And Bill Kidd.
Thank you. And thank you for being here, Minister. Now, Section 5 of the bill confers a wide power which permits the amendment of primary legislation and the creation of criminal offences. And how will the Parliament then, how will this Parliament be assured that substantial policy changes such as these made under Section 5 will be able to receive adequate scrutiny given the breadth of the power and the limited detail which we have on the face of the bill as it stands at the moment?
I thank Bill Kidd for his question and recognise the work that this committee has been doing on framework legislation. And I would just like to underline that I do not believe that this is framework legislation. I believe it has got very substantive powers within it, which really focus us towards ensuring we get the right public health outcomes from this legislation when it comes to non-surgical procedures. And I think, as I've said in my response to Katie Clark, that it's important that this legislation is able to respond to changes within that sector, to remain relevant and to protect the public from potential harms. I understand the point that you're making around scrutiny, and I think that's very important. And from my perspective, we have been working very close with the cosmetic clinicians, and I've also had meetings with businesses as well. And I think for us to ensure that we get the right legislation and any changes that are currently not on the face of the bill, that we continue that close engagement, because the people that I've been working very closely with and the people my team have been working very closely with want to ensure that this area of work is as safe as it can be.
And can I just ask then, on the basis of that, and I do understand what you're saying, because it's very important that it's properly worked through and developed as much as possible as a bill. Is there going to be an educational side to this bill as well that will actually sort of make the public aware of the dangers that can take place if it's not properly conducted?
So I think that's a really good question, and something that has come out again in a lot of the conversations that I've been having with stakeholders that have been feeding in. And I think that's really important in some respects. Yesterday, when I was driving to my constituency, I was listening to Radio Scotland, and they had a piece on cosmetic procedures and the evidence that the Health, Social Care and Sport Committee are taking just now. And all of these pieces of work in the media are helpful, very helpful to ensure that we get the right message across. And I think if we were to look at that, then I would be very content to take that away and consider what we could do more in that space.
Well, that's very good. That's very helpful. Thank you for that. Thank you.
Yeah, thank you. And Jeremy Balfour.
Thank you. Thank you, Convener. Good morning, Minister. Good morning to your team. I'm wondering, would the government consider placing additional statutory constraints, such as guiding principles or limits on the purpose of the power, on the face of the bill?
So we've had a discussion about that. believe the bill as it stands gives us the right controls around the powers that we are looking to, because, as I've said previously, it is a very fast-changing environment. I'm happy to take your question away and look at it further, but I think as it stands just now, the bill contains the right safeguards and controls and the right flexibility so that we can respond very quickly to any changes that are needed.
Okay. I'm grateful. If you have any further reflections, perhaps you could
Of course.
write to us as a committee.
Of course.
Thank you, Minister. Thank you.
Okay, thank you. And Minister, what consideration was given to including statutory consultation requirements to ensure that transparency and stakeholder input before regulations are made under Section 5? Just before you do answer, with that particular question, I was thinking of, going back to what you've already said this morning, that need to have that flexibility and to act quickly, because the industry itself is so fast moving. But still having that opportunity to have that level of consultation, which in the grand scheme of things still wouldn't take up a vast amount of time.
Mm-hmm. So I think that's a very good question, and it's one that we've been discussing as well. And as you know better than I do, there are the affirmative and negative procedures. And if it was a new procedure that we were adding into this, then that would follow the affirmative process in Parliament, which would allow this committee to consider it, and then clearly there would be the parliamentary vote. However, if we were looking at something like the documents to prove age, then that's not a policy change, that's just a procedural change. So therefore that would be a negative area. And I think I think it's important that we get this right, which is why we've been quite clear as to which procedures follow either the negative or the affirmative process.
Okay. Okay. No, thank you for that, Minister. Do you have any further questions for the Minister? No. Okay. Okay. Thank you, Minister. I'd like to thank you and your team for your evidence this morning. That's been very helpful for us. So that now concludes the public part of the meeting, and I'll move the committee into private. So thank you very much. Thank you.